Good evening, everyone. It's on or about 6:30, so I'll call this land use planning meeting to order. And I will begin with a motion from Councillor Anderson, seconded by Councillor Bateman, that Council approve the December 14th, 2020 Council meeting agenda as presented. Is there any discussion? All those in favor? Are there any opposed? The motion's carried. And before we move into declaration of pecuniary interest, I will note for the public that council is here at 35 Alice in council chambers, 6 feet apart, with our Director of Planning and Development, Mr. Walsh, and our Deputy Clerk, Mr. Street. We are being joined through Zoom by our clerk, Ms. Doran. Is there anyone else joining us by Zoom, Mr. Street? No. And then the general public is able to watch these proceedings through YouTube. Members of council, do you have any declarations of pecuniary interest? And if so, please state the general nature thereof. There are none noted. We have no delegations this evening, which takes us into our statutory public meeting. Mr. Street, I don't have a motion to enter into the statutory public meeting, do you? So I need a mover that council enter into the statutory public meeting at 6:32 p.m. Is that moved by Councillor Anderson? Seconder, Councillor Rowley. Is there any discussion? All those in favor? Any opposed? The motion's carried. Now, I have been asked to read the following when we go into a land use planning statutory public meeting, so I will be doing that every time we do so. The statement comes from the regulations from the Planning Act. If you wish to be notified of the decision of the municipality of Brighton on the proposed development application, you must make a written request to the clerk of the municipality of Brighton. If a person or public body would otherwise have an ability to appeal the decision of the municipality of Brighton to the local planning appeal tribunal, but the person or public body does not make oral submissions at a public meeting, or make written submissions to the municipality of Brighton before the bylaw is passed, the person or public body is not entitled to appeal the decision. If a person or public body does not make oral submissions at a public meeting or make written submissions to the municipality of Brighton before the bylaw is passed, the person or public body may not be added as a party to the hearing of an appeal before the local planning appeal tribunal unless, in the opinion of the tribunal, there are reasonable grounds to do so. We have one item in our statutory public meeting this evening. It is to deal with file number Z09-2020. The owner is Gary Adams. The applicant is Tyler Freeman. The location is part of Lot 36, Concession 4, Part 1 of Plan 39R, 14171, 174 Donaldson Road. Mr. Walsh, by what method and on what date was notice of this zoning bylaw amendment application given?
To the Mayor to Council, the method of notification was given by first-class mail on November 23rd of this year to all property owners within 120 meters of the subject property. The application was also circulated to all appropriate agencies as required on the Planning Act, and a signed notice was also posted on the property.
Thank you, Mr. Walsh. And would you please explain the purpose and reason for the proposed zoning bylaw amendment and what it would accomplish?
The zoning bylaw amendment application was a condition of consent to consent file number B01-20 under the same name as the zoning bylaw amendment. The zoning would apply to an approximately 1/2 acre lot, moving from a rural zone to a rural residential zone. The 13 hectare retained lot would remain in the rural zone and the environmental protection zone.
Thank you, Mr. Walsh. Mr. Street, is the owner or applicant available to us on Zoom? They are not. Mr. Street, are there any persons present through Zoom who wish to make comments or have questions regarding the proposed bylaw amendment? There are not. Are there any questions or comments regarding the proposed zoning bylaw amendment from members of council? Councillor LeBlanc.
Through you, Chair, through the planner. This is the second time this file comes in front of us. Can you give us a reason why it's coming a second time?
Mr. Walsh.
Through the mayor, the first time around, it was to consider the application for severance. And the decision of council that time was that prior to finalizing the consent, that a zoning bylaw amendment be brought forward to council for its consideration and approval, subject to the terms established within that consent decision of council. And so they need to complete this zoning bylaw amendment application within 1 year's time of the notice of the decision being sent out. And these things are stipulated under the Planning Act. So if they don't get this done within a 1 year time frame, then the application is deemed to have expired, and they would have to start the process over. So it's a bit of a two-phase process, but I think I don't know the particulars why this was done in basically a two-phase process, but I think in the future I would encourage maybe that a consent and rezoning be done concurrently if the need for the zone amendment can be identified in the early pre-consultation stages to the application.
It's not unusual, hasn't been unusual in Brighton for us to have them separated, but I would concur that a more efficient way of doing it would be to bring them together if we're able to. When was remind me when the severance application came forward? Was it May?
Yeah.
No, it's in the report as May. So we're well within the year. Yeah, thank you. Councillor LeBlanc.
If nobody from council has another question. I should have been more defined. This survey, it was brought to staff, and then they requested it to be resurveyed a second time, the part of the question. My second part to the question is this significant woodland. Under the provincial's thing, there is no designation for body of size, but Brighton has taken and put in 0.5 of a hectare. So it would be much better if we would have 50 hectares, which would give us 120 acres, because when you say 0.5 of a hectare, 1.1 acres, that means a study, an EA study of $6,000 goes with every lot and everything, because everything ends up in the town, in the municipality, as being a significant woodland, because most of them there. And since there's no designation with the Northumberland County or with Lower Trent or with the municipality, we picked this number. Could we pick a larger number so that some of the EIS studies wouldn't be required for every small severance of a 0.5, an acre, 0.1, because it's essential cost to a young couple that wants to start a new home and start something, and they had to survey it twice for this thing because it wasn't picked up on the first review by staff. So this is why I was asking that question. Okay, and so two-part question. One is why was it had to be surveyed twice? Second one is, can we look at the significant woodlot so we can make it a larger one, so we wouldn't have to go through all these studies and habitat at risk for small parcels of land?
Mr. Walsh.
Through the mayor, the council. One, the reason for a second survey, normally it's useful to have a surveyor's sketch, not a full reference plan, surveyor's sketch at the time of application for a complete application, because they'll do a bit of title search and they'll verify a few basics so that council can be well informed for its decision. And it's useful also if there's existing development on the retained or severed to get some kind of billing locates, that sort of thing for purposes of zoning. So all that is very useful information, and sometimes we need that accuracy that a surveyor can provide. I'm not really sure the need for a second survey per se, other than there should have been probably more clarity in the wording of the conditions for things like road widening and that sort of thing. If it were that they did their survey and then got around to doing a condition of the consent that also required some related survey work, and that wasn't well understood through the wording of the decision, then staff should be working on that wording and making sure that it's clear what survey information is required. Normally, when I draft reports to try and keep all conditions, try and keep all that survey-related information in the one condition so that when the surveyor picks up our notice of decision, it's all there and they don't zoom in on the one condition and miss something else. So staff will be much more cognizant of that in the future and will be focused on some of the specific wording in the conditions to make sure that applicants are aware of that. And perhaps maybe we should have also maybe an annual little workshop with the surveyors so that we can see what works for them and learn from them, and they can learn what our needs are and generally find internal efficiencies accordingly. On the second question about the EIS, so that's triggered by the Places to Grow Act, and through the Natural Heritage Information Center, they have some prescribed information that they've been bringing into the Places to Grow Act mapping. So when we need to make a decision under Section 5 of the Planning Act, this municipal planning authority can make a decision that's generally in conformity and not in conflict with the Places to Grow Act. So we see that DM Wills, specifically Daryl Ty, has had the regard he's had to give under the Planning Act for the Places to Grow mapping. So that's what triggered the EIS. To your point, that we should be a little more articulate as to when this really gets triggered. Maybe it's not necessary for small scale instances. I generally concur. And some of the solutions to that would be having a best practices set of conditions. So when fronted with this kind of situation in the past, such as development on cold water bodies, which is also considered sensitive, these sorts of things, I found that the EISs, environmental impact studies for small scale developments, tend to have the same set of recommendations in terms of best practices, avoiding different things and encouraging certain other things. So I got away from actually asking for a study and getting right to the typical conditions. And as long as staff were comfortable with those typical best practices that normally are found in the recommendations and conclusions of an environmental impact study, then I would just apply them directly and avoid the study. And to my experience, that's worked out well. So I hope something like that can work out for small scale developments dealing with significant woodlands. And further to your point, and sorry, it got me going, but the Natural Heritage Manual that's been issued by the province for determining what is a significant woodland does encourage certain minimal scale of woodlands before they're deemed significant. Reason being that, and shape even, so that woodlands aren't connected by a narrow strip of trees, that sort of thing. So the continuity and contiguity of the woodlot is important for it to be considered sustainable for the purposes for which it was originally identified and the features and functions for which it was originally identified. So, I would generally concur that if you're at the edge of a small woodland, it's probably not going to be triggering major concerns in terms of impacts on the natural environment. Now, the county has since, through its natural heritage study, developed its own significant woodlands layer, and it's about to be implemented, as you may have read, may you recall reading the report. And then ideally, this municipality would also amend its official plan to adopt some of the upper tier determinations. And normally we can be a little more focused and defined in some of these determinations. Usually the wording in an upper tier official plan will give some flexibility for the local municipality to drill down into some of the more detailed considerations. So when we update our official plan, hopefully we can do so.
Thank you. Councillor Anderson, did you have a question? Councillor Tadman?
Mayor, so when you first get an application, a single one like this, and my understanding is that in the rural area,
Councillor Tadman, could you draw your microphone closer to
Sure.
you? Thank you.
that it's required unless you get a minor variance for an acre lot. Is that correct still?
Through the mayor to council. So Normally, if we're going to do a lot that's a bit smaller than required, we would probably just, and we're rezoning anyway, we just do a special rezoning.
Okay, so at that point, does somebody from planning go to, because I did, and I happen to know Gary Adams, went to school with him, so I went out, saw his place, saw the other house there, and where the sign was for this new one. And I saw a bunch of kind of scrubby looking trees. So would you always order that you have to have an impact study on a single dwelling? If it was pretty well like that one has pretty well covered with old pine trees, a lot of them have fallen down.
No, not normally, through the mayor. Not normally. What really triggers it is the place to grow at mapping. And once the county official plan, natural heritage mapping is in place, then we would just simply follow it.
And just as a comment, the right part of all that is that their mapping is terrible. And so young or anybody that is wanting to build, I understand it's going to cost them about 6,000 extra before they even get started. And there must be a way around this.
Yeah, through the mayor to council, I think it's the best practices approach. If we can get there, it'll vary from site to site for sure. But I agree that there's probably a way to get to the end in mind and find more efficiencies in the process to get to the same ends. And again, I think we can rely on, the provincial mapping is very broad brush, very general landscape approach to doing things. We can, through more data sets that I think might be available, that we can be a little more refined. And if the development is, as you described, small scale, then we can focus on mitigation measures or how we can best fit that situation as opposed to asking for a major 4-season study. Yeah.
So good discussion, an important discussion, and thank you for the answers. It's important for council to understand the processes and why we go down the roads we go down. If you have a question specific to this file, go ahead. Yeah.
I very much understand if it was a subdivision in the rural area and there was a lot of trees. Yeah, then of course, but I think we need to find a way to get around this.
I think probably the best way to get around it would be to ensure that our planning staff was robust and positions were filled and planning applications stayed here in Brighton's planning department. That's not a criticism of the planning consultant, but I think things are always better handled locally for local matters. And that's why we are the planning authority for the municipality. So I think that's probably the best solution. It's one we continue to look for. So we'll keep going down the road. Specific to Z09 2020, please. Go ahead.
Your Honor, Mayor, all the questions have been to this file and only this file. Thank you very much for your answer, Director of Planning. I have just one more. How, as a council, or me as a council, what would you require from us to assist you in making these files less costly and try to reduce the cost of homes and rezoning and not having an ES study? I know that there's one coming with 3 lots, another one coming with 4, another one coming with 2. If they all require an EIS study and different types of water modeling, you're requesting is $70,000. And these EIS is another $24,000. We're trying to reduce the cost of homes on young families starting to go. Not everybody wants to be in the urban area. Some people want to be in the rural. And if you can use woodlots or woodland, scrub woodland, instead of using prime farmland, it's a place to look at. One of the things is to make the significant woodlot thing a lot larger, which wouldn't trigger these. And to come to the comment to Mary Tadman, the mapping, unfortunately, I'm ex-military and I understand mapping very well because we had to be within 1 meter. And when I look at the mapping that you proposed here and I drove the property, it's way out. It's like I said on another file, you had the stream north of the barn and it's south of the barn by almost 200 meters. This one is almost the same where the bends of the roads are. And since we've gone into all this new equipment, new software, hired personnel, you know when we're gonna mesh this all together so that the drawings match what's actually on the sites?
Through the mayor. Well, I'll give one example. I can give more than one example, I suppose, but the
Let's
immediate
stick to one.
example.
Let's stick to one.
Okay. The immediate example that comes to mind is improving the EP zoning and designation. And in preparation for the secondary plan, I've been dialoguing with some remote sensing specialists who have access to different satellite imagery, infrared, etc., and aerial photos during the springtime condition, leaf-off condition, so you can see the ground. And doing a composite of those different sources, I think we can get a much better refined EP zoning and designation. So that's the objective. And yeah, I've worked with some air photo interpretation that has been really bang on. Yeah, I know it's doable. So that's what I hope to get to.
Okay, thank you. Thank you.
Thank you. Any other questions from members of council specific to the file? No, thank you. And Mr. Street, the owner applicant, weren't with us before, but are they present now for final comments by chance? No, they are not. Mr. Walsh, do you have any final comments?
Nothing further, Mayor?
Does council wish to make a decision? Thank you, sir. Does council wish to make a decision at this time on this zoning bylaw amendment application? That being said, I have a motion moved by Councillor Bateman, seconded by Councillor Anderson, that council receives the report regarding rezoning application Z09-2020 as prepared by the municipal planning consultants, and that council enacts a bylaw to rezone the severed lands of consent application B01-2020 rural zone to rural residential exception number 49 zone. Is there any further discussion? All those in favor? Are there any opposed? The motion's carried. And I'll need a mover and a seconder for the motion that council adjourn the statutory public meeting and return to the regular council planning meeting at 6:52 p.m. Is there a mover? Deputy Mayor Vink, seconded by Councillor Bateman. Is there any discussion? All in favor? Any opposed? Motion's carried. That takes us to our planning and development reports. First report is with regard to part 2, motion MD 791, resolution COU 2020-274, that staff provide recommendation to council under draft bylaw or guideline for fencing. Mr. Walsh, we've read your report. Do you have anything to add or highlight, sir?
No, sir, nothing to add.
Thank you. I have a motion moved by Councillor Tadman, seconded by Councillor Bateman, that the report dated December 7th from the Director of Planning and Development regarding a fencing bylaw be received and that the draft fencing bylaw as attached to this report be enacted. Is there any discussion? Councillor Bateman.
Just for the Director of Planning, if I could, Paul, this is going to be grandfathered in, correct, if we pass it?
Mr. Walsh.
Through the mayor, yes, there's a provision within the bylaw deeming all existing fences to be in compliance.
And just
ahead.
one follow-up. Under 2.7, when it talks about drainage, and I agree with the grandfathering in, but if you go throughout the community now, if there's any fences that, because 2.7 talks about drainage, no person shall construct a fence or drainage easement in a drainage easement, swale, or water course to obstruct the flow. If you drive throughout the community, there's some there now, whether they're fences, sheds, flower gardens and stuff. Will they be grandfathered in, or if staff notices something that's existing blocking the flow of water that could cause flooding, would they be exempt from? Because I personally think they shouldn't be there, because you put a fence in the easement, it might not flood your house out, but it might flood your neighbors out. I don't know if they should be grandfathered in. If somebody's blocking it, there should be something done with those to not necessarily take the fence down. It speaks to making sure that there's a spot where the water can flow under the fence. But
Certainly lots of drainage concerns in the municipality. Mr. Walsh, you have an answer to that?
The section 3.1 fences deemed to comply is fairly generally encompassing. So unless we've received a complaint and it's an actual item before us now presently, then it would remain deemed to comply to this bylaw. In its
But
current
if,
wording.
but if a complaint was received, even if it's an existing fence, we would investigate.
Yes, it would be wise to maybe do an amendment to the wording of the bylaw to maybe refer back to the property standards bylaw or have a notwithstanding provision within the deemed to comply. So staff could take that back if council's considering this to be a priority. It's not a complicated matter, and staff understand that and generally concur with what's being suggested, that if there is some egregious out there, then perhaps deeming it to comply should not be permitting the aggravation.
Thank you. Councillor Rowley.
Thank you, Mayor. My question has to do with our fence viewers. Will this eliminate the fence viewers and now it will be just a bylaw inspection?
Mr. Walsh.
To the mayor, no. There's the bylaw says that the role and the function of the fence viewers shall be maintained.
Councillor Tadman.
Thank you, Mayor. I'm sure Deputy Mayor and you, we were on the last council where there was a lot of problems with people deciding they didn't like swales and they put bushes, whatever in them. The other problem is too with ditches. Some people don't like ditches in front of their place, so they fill them in. That's not a fence. That's not a offense, but do we need to start thinking about that too? And I know that there's one area close by me that didn't like a culvert, so they took it out too.
I think those are issues that would be
Especially
especially.
it has to tie in somewhere, but I don't think it's here.
It's not here, no. And certainly with ditches are almost always on municipal property. So
Well, yeah.
people altering municipal property can get in big trouble if they're reported to the municipality, but sometimes we just have to find out about it.
Okay, so if they're charged with an offense, is that a provincial offense? Do they collect the money like this?
If people are altering, and we're getting off topic a bit, but if people are altering municipal property, they wouldn't be necessarily charged with an offense. The municipal property would be corrected by municipal staff and charged back either by direct invoice or through their taxes. Am I
But it is
offside
an
there?
offense. It's not their
on so
property.
many levels.
Yeah.
Yes, on so many levels. Councillor Anderson, you had a question.
Councillor Bateman made a good point, and I've seen what he's talking about in areas of the municipality too. But I think there are rules regarding putting a fence across a stream or a watershed. Like I'll just pick Smithfield Creek, for example. I don't think you can put a fence across it. And I don't know whose jurisdiction that runs under. Does it go over? Is it Lower Trent or is it the province? Is it the? But he make a good point, and I'm just using that particular body of water as an example. But I'm sure there's lots of small streams and things that have different types of fencing going across them for different reasons. And who knows how high they should be built, and some have probably sunk anyhow. So there's potential for problems. So how would you address the problem if and that's what the councillor was saying. How would we address that if it happened where it caused a problem?
Mr. Walsh?
Through the mayor, there's a section in the bylaw itself, section 210, about fence not being permitted in the environmental protection zone. And presumably the conservation regulations would also apply. So it's kind of some double protection there. In some instances, for whatever reason, maybe there won't be regulations in that particular situation, not fairly commonly, but I think that would be a belts and suspenders approach to safeguarding the EP areas.
So is it council's wish that we refer this back to staff for some amendments, specifically with regard to the fences deemed to comply section? Yes. Councillor Bateman, did you have another question?
Yeah, I just wanted to ask one more for clarification if we're going to be sending it back. If this gets passed, it's for fences going forward. What if a fence is reconstructed, similar to the sign bylaw? If a sign is broken and they put another one up, it's not the exact same dimensions, it's another whole permit. So if somebody has a fence and they have to do major repairs to it, does that fall under this, or they can do it without? I didn't know if it's two different things.
Yeah, generally, as long as you're doing maintenance or restoration of an existing structure, then there wouldn't be any enforcement of that otherwise non-compliant structure or facility. And I'll look for clear language in that regard if it's not there.
Deputy Mayor?
This is a fence bylaw, but it doesn't require a permit, does it?
Mr. Walsh?
No permit required.
Thank you.
Councillor Tadman?
As I read through it, I didn't exactly, I wasn't exactly assured that I know of a situation where there's a fence falling over onto other people's property. And as much as they've asked if they would, it's their fence, the neighbors, they put some poles to hold it up. At what point can, as a municipality, us force someone to, the fence should be repaired or a new one put up? But I don't see anything here that forces them to do that.
Mr. Walsh?
Through the mayor, there is a section about maintaining stability of a fence. And it's
Okay.
one item in a bit of a list there. I
Yeah, I
forget
was
which
reading
section
it,
is.
but I didn't necessarily see what happens.
Okay. And if I recall correctly, there's also a provision in the property standards bylaw that we updated recently.
Okay.
Yep.
Because it could be a danger with small children. It's a big fence and it could fall on top of them.
Deputy Mayor?
Thank you. Just further to that, just for more clarification. So with this fence bylaw, we're saying every fence that's in existence is deemed to be complying with the bylaw, but there are fences that are falling over. So what you're saying is, well, maybe with the revision we're making now, that maybe can be, we were talking about when they're built over swales, but if there's existing ones that are falling over, we still need to be able to do something about that. I just want to make sure we're able to, we're not tying our hands with this by saying that everything that's in existence is complying, because they're not.
Mr. Walsh?
I'll circle back to that property standards bylaw. I think in anticipation of some of the fencing issues and obligations for proper maintenance going forward, something was incorporated in that. I think that's what I recall. But failing to having done that, I think in making revisions that will be covered when this is brought back.
Thank you. Councillor Tadman?
Thank you, Mayor. So the residents that are concerned about this particular fence or any others that have spoken to me about some problem fences, do they get in touch with you? Who do they get in touch with then?
Through the mayor to council, they would just preferably fill out the complaint form that we have. And then that'll give staff a bit of a walking orders to follow up on it and with some specifics involved. And we'll follow up accordingly.
Okay, just to follow on that, in our procedure bylaw that I was reading today that Candace brought out, we're supposed to take everything through the CAO. My experience in the past is I like to go to where I'm going to get some answers.
Well, any member of council can fill out that complaint form too.
But is the procedure bylaw telling me now that if I want to talk to Paul about a planning issue, I can't do that?
I confess that I haven't read through the procedural bylaw provided to us by staff today. It's sitting on my desk. My plan is to read it through this week. So,
because that comes down to what does a resident do?
sure. So residents can certainly contact members of staff. The issue,
Anyone,
the issue,
but we can't now?
right, because we are governed under the Code of Conduct, which, because we are a board of directors for the corporation, the only person we as a council truly employ is the CAO. And for us then to go to a director directly sort of violates that employee-employer relationship that we have with the CAO and other municipal staff. So I don't think generally our staff have an issue if we're just dealing with the director level. But when it becomes a problem, then, you know, we would go back to that procedural bylaw and the code of conduct if there became a problem, to direct people back to the CAO.
So are you saying, Mayor, at this point, I can still talk to the planner instead of going through the CAO?
I think if you're good and polite and you're not providing direction, everything would be fine.
Oh, I know all the rules.
Yes, I know you know the rules, but we also have to follow them. Councillor Tadman, we have a motion in front of us, and it's your motion. And the last line, with your permission, will be amended to read that the draft fencing bylaw be referred to staff for amendments as discussed. That's fine. And Councillor Bateman, you're the seconder. You're okay with that? Mr. Walsh, does that make sense to you?
Yes, I've made notes here, so I know what to
you
do
very
here. Thank you.
much. Is there any discussion on that, given that it's been amended? All those in favor? Are there any opposed? The motion's carried. Our next report is with regard to backyard poultry, proposed amendment to the comprehensive zoning bylaw number 130, 2019. And Mr. Walsh, we've read your report. Do you have anything to add or highlight?
Nothing further, Mayor?
Thank you. I have a motion moved by Councillor Rowley, seconded by Councillor LeBlanc, that Council receives the staff report regarding a draft zoning bylaw amendment that revises the existing backyard poultry provisions of section 4.41, and further that staff proceed to give public notice for a statutory meeting regarding the proposed zoning bylaw amendment for the January 11th Planning Council meeting. Is there any discussion? Councillor LeBlanc.
Through you, Chair, I wish my my app would open, but I think I remember the question. Through to the planner, does this new bylaw solve the problems that came in front of council?
Mr. Walsh.
Through the Mayor, yes, it would. Mr. Tim Nurse was in a legal non-conforming zone, so there's a provision saying any home in a legal non-conforming zone will be permitted to have a maximum of 6 hens, subject to the other provisions.
Any further discussion? Councillor Tadman.
Just to let you know, it's so interesting that this is tonight, and someone phoned me and said there was chickens on Prince Edward Street today. So that would not be a good thing. They're not allowed in the urban.
Certainly not the number of chickens I've heard about anyway.
Oh, more, yeah, okay.
Mayor, there's just a question, did they cross the road?
My understanding, Mr. Walsh, is they have not yet, but there is some concern that they may try.
Well, they did tonight.
Oh, there it is.
Yeah.
If
And
only,
what was on the other side?
if only we knew why. All right, anything further? Councillor Rowley.
Thank you. Just in that little bit of a discussion. So no chickens allowed in the urban area at all?
Mr.
Is
Walsh.
that what I just understood?
No,
you
through
to-
the Mayor, yes, there would be permitted
Yeah.
keeping of hens in the urban area,
Right.
in the R1 and R2 and R3 zones.
Yeah.
yes.
Okay. I was just
But it's a maximum of 6.
right.
And
Yeah.
they-
That's what I was thinking, and I was just kind of misunderstanding maybe the
And they must be
conversation.
hens.
Yeah.
And they may not be used for
May
eating.
not be roosters.
Councillor Bateman.
I think there were specific dimensions for the coops and everything else in your document as well, right?
Anything further? All those in favor? Are there any opposed? The motion's carried. And we'll see that come forward in January through a statutory public meeting. There's no unfinished business this evening, which takes us to bylaws. Well, we referred the fence regulation bylaw to staff for a report. Which brings us to general fees and charges bylaw, moved by Deputy Mayor Vink, seconded by Councillor LeBlanc, The council gives a bylaw its first, second, and third reading and finally passes on this date, being a bylaw to establish general fees and service charges for the municipality of Brighton effective January 1st, 2021. Is there any discussion? All those in favor? Any opposed? Motion's carried. And the next bylaw is with regard to establishment of a water and wastewater fees. Moved by Councillor Anderson, seconded by Councillor Bateman. The council gives a bylaw its first, second, and third reading and finally passes on this date, being a bylaw to establish water and wastewater fees and service charges for the municipality of Brighton effective January 1st, 2021. Is there any discussion? Councillor Tadman?
Just as most everything's blamed on council that people don't like now an additional charge for the garbage tags. We get blamed for the price of water and sewage, but that's set by a consultant that does a study of everything that we need to function in our water department and our wastewater. So I don't know how we get that out to the public, but I know people get mad when they get their bill and they say those damn counselors and that mayor, what are they doing to make us? And it's the same with the garbage tags.
And at the end of the day, you're quite right. We aren't supposed to. We aren't really permitted under the Ontario legislation to use tax dollars to support that. And certainly our rural residents would probably lose their minds if we started to, and rightfully so, since they pay for their own water and wastewater systems. But we have to cover the costs of these things, and it's not a cheap endeavor.
And it goes the same for the county roads. We get blamed for the poor shape of those too. But I don't know how we let the public know that, some things are our fault, but most things aren't.
I'm just going to let that one hang out there. Is there any further discussion? All those in favor? Any opposed? The motion's carried. Next bylaw is with regard to planning and building fees and services charges. It's moved by Councillor Bateman, seconded by Councillor Anderson. The council gives a bylaw its first, second, and third reading and finally passes on this date, being a bylaw to establish planning and building fees and service charges for the municipality of Brighton effective January 1st, 2021. Is there any discussion? Councillor Bateman.
Just a question more from my understanding, and it really applies to the earlier one on here for the fees, the municipal fees. Oh, I just lost it. Under note 1, I think it said if building commences before the permit, the fee can be doubled or will be doubled. How does that work? Is it automatically doubled, or is that at the discretion of the staff at the time? Because it says the fee calculated in accordance with Schedule B above shall be doubled in instances where the construction commences prior to the building permit. And it applies to the same thing under the fees for signage and stuff. Is that an automatic thing if it's noticed, or it's case by case?
Mr. Walsh?
Through the merits, as you may appreciate or anticipate, that there are those out there who choose to avoid taking out a building permit application. So it's really intended for those persons who've tried to evade getting an application in, and then the application fee doubles. Sometimes there's a gray zone. Oh, I don't know I needed a permit for a swimming pool. And in which case, if there's some justification for it, and they really, quite willing to halt their commencement, then the CBO uses its discretion from time to time. But generally speaking, it's to be fair to all is being consistent with our rules. So we try and be consistent with it, unless there's a clear exception to be given.
Councillor Tadman?
And follow up with the Councillor Bateman's question. So how do we invoice that? Does that go through the planning department? And do we make some money off that?
Mr. Walsh?
Yeah, so that fee there, so they double their application fee essentially. So it's just instead of applying for a building permit application at the regular fee, now they have to apply for it at the double the fee. So that. Correct, because our chief building official would issue a stop work order if they tried to undertake work that requires a permit to be approved before work commenced. So a stop work order would be applied, and if they ignore that, then the other offenses that would then get invoked.
Your microphone, Councillor Dadman. Your microphone.
I just wanted to know that it's immediate.
That's
You know,
correct.
we
It is
don't have
immediate.
to
They
hire a lawyer to get the extra.
no under the Building Code Act, the building officials have some fairly strong authority.
And out of my curiosity, if they fail to pay, is that another instance where it would hit their tax roll?
I believe so. I think it might be under the Provincial Offences Act to get it onto the tax roll. We might have to apply administrative monetary penalty, but yeah, some things are applicable to the tax roll, some things aren't. Being under the Building Code Act, it might be on the property since it's construction related. I probably have to verify that to give you a clean answer.
I'd be curious if you have a chance to look into that. It's nothing urgent though. Anything further on this one? Go ahead, Councillor Tabman.
Further to that, I know Lower Trent Conservation, when they have somebody that's interfered with wetlands or whatever, and they have to pursue that in court, even if they win the case, they don't get any money. It costs them money to hire lawyers and their own staff. So if we got to what the mayor was talking about, would it, once it becomes a provincial offense, then they would get the money and we'd pay the bill.
That's partly true. Other things, the fees come back to the municipality. A lot of parking fees come directly to the municipality. But if if we elevate it to the Provincial Offences Office, then yeah, I think it goes into a general pool. And then as a member of the municipality of Northumberland County, we get a portion of that pool. And often, yes. That's right, and that's why municipalities are looking at different options, like the administrative monetary penalties. And so far, what I'm hearing, it hasn't been so much of a problem in the municipality of Brighton to date. So, but we do have that tool to call upon when needed. It's not for the faint of heart type of bylaw. You need to have a designated hearing officer, intake officer, and clear procedures in place. You have to be quite ready to be audited and things like that. So our volume probably isn't there to really justify it unless we wanted to partner with another municipality to develop a program which even larger municipalities have done to do so.
Thank you. Anything further? Go ahead, Councillor LeBlanc.
Through your chair, for the planner, with these new fees, are they going to help recovering all the costs so we're not in the hole in the planning department as we have in the past? Will we become neutral?
Through the mayor, it's hard to predict the volume. It's quite volatile. One major application can raise your revenues to beyond what your planned budget would be for your revenues. So that's not uncommon. Other years, it's the opposite situation. It probably won't, unlike the building code, the Planning Act doesn't require that there be a cost neutral model in place. The logic being that good planning is good for the community at large. Unlike the building code where administering of that permit is for that person doing the construction, and we do seek to have a neutral cost revenue model as required by the building code. But I think there might be a couple of lines in there I wouldn't mind revisiting at some point. And so maybe we'll bring that forward in January. I think our fees are pretty good on the subdivision side of things, but maybe something in terms of the consents and whatnot could be reviewed. It looks a little bit low compared to other jurisdictions. So I think the idea is to get this in place for now. And then when we come back, I want to do a more fulsome review of our model or cost model. Then we can revise a couple of lines in the planning and building department's fees and charges.
Go ahead.
Since you brought up subdivision, in the past, we've had problems with people walking away from their grading plan fees. Is there any way, is that going to be taken care of, that we raise them again so that the people, it doesn't make it good for them to walk away from them, that they'll actually do the grading plan correctly?
Mr. Walsh?
Yeah, right now we charge $2,000 or $2,500 for a grading and drainage plan associated with a lot on subdivision. So that's administered through the subdivision agreement. So a failure to really administer or to execute the commitment that they've signed on for the subdivision agreement, we really hold, we can really invoke the fullness of the agreement to the benefit of the municipality, and making sure that gets done. So I'm not sure why people are walking away from their grading and drainage plans. There's key triggers in the subdivision agreement as to when those are required and when there's going to be a release by the municipality representing that we're satisfied it's been met, and then release that security or deposit of the $2,500 back to them. So that $2,500 is there to make sure they do that. So, you know, we still have the fullness of the agreement to work with, and we should just be adherent to the provisions of the agreement.
Anything? Go ahead.
Thank you, Mayor. My question is about inspections under the building department. I know here listed there isn't very many. I believe that because some of our inspections are done through the county right now. Will that come back to the municipality
Just
at some
plumbing.
point? I'm sorry?
Just plumbing.
Oh, it's coming.
Just plumbing.
Oh, just plumbing? That's the only one that's done through the county? Okay, I thought there was more. Okay, so, okay, my question will still be, is that something that the municipality will be considering bringing back in-house at some point or not?
Through the mayor, speaking with our chief building official, he's prefers it to stay with the county. It is a bit of a specialization, and particularly with related to that are septic systems. So with septic systems, you know, there is a bit more, I guess, perceived liability with that, because putting a septic system in, say, too close to a well and that sort of thing, that you can have some inferences of that. I mean, I have raised that question internally, but the feeling I think among the chief building official is that it's been very useful having it at the county for now.
Deputy Mayor?
Thank you. I just wanted to comment on that because I believe that was the last term of council where he made that change, and I voted in favor of it because it's like having the building inspector inspect your wiring. You have an electrical inspector do that. The plumbing should be done by someone with plumbing experience and a plumbing inspector. It just makes more sense that our building inspectors aren't tasked with having to know that specialty as well, because and the rules, of course, plumbing and electrical, those rules are changing all the time as well, just like buildings. So it's just more. So I think it's actually better being done by the county.
And I recall that this term of council, we re-signed up for that for a multi-year term. So, Councillor Tadman.
And I think we all agreed that because of the Clean Water Act too, that and especially the inspections that have been going on where there's septic tanks that are not in compliance, you can't expect one person to be able to do all of that. You'd have to hire somebody that has the expertise. So why not share that with the other 6 municipalities and have one person that knows it? So I think that's what our final decision was.
I believe so.
Yeah.
I don't think we share it with all 6. I think it's 5. It's either 5 of us or 6 of us. There's at least 1, maybe 2 municipalities who do their own.
Oh, okay. Well,
I think the 2 larger centers do their own.
well, that makes sense.
Yeah.
It's like Quinte West does a lot on their own too. Yeah, okay.
Anything further? All those in favor? Any opposed? The motion's carried. Next bylaw is with regard to the zoning bylaw amendment Z09 2020 that we discussed in the statutory public meeting, and it's moved by Councillor Tadman, Seconded by Councillor Bateman that council gives this bylaw its first, second, and third reading and finally passes on this date. Being a bylaw under the provisions of Section 34 of the Planning Act, RSO 1990, to amend bylaw number 140, 2002, as otherwise amended, of the Corporation of the Municipality of Brighton as it applies to certain lands located in Part Lot 36, Concession 4, Part 1, Registered Plan 39R, 14171 in the Municipality of Brighton. Is there any discussion? All those in favor? Are there any opposed? The motion's carried. Now we move into question period, but we have no one on Zoom to ask any questions. Thank you, Mr. Street, for acknowledging that. We have no in-camera session this evening. We move into our confirmatory bylaw, moved by Councillor Rowley, seconded by Councillor LeBlanc, that council gives a bylaw its first, second, and third reading and finally passes on this date. Being a bylaw to confirm the proceedings of the Corporation of the Municipality of Brighton Council meeting held on December 14th, 2020. Is there any discussion? All in favor? Are there any opposed? The motion's carried. And a motion moved by Councillor LeBlanc, second by Councillor Rowley, that the December 14th, 2020 planning meeting adjourn at 7:26 p.m. Is there any discussion? All in favor? Any opposed? The motion's carried.